you, Cindy. Our next speaker is Clinton Hughes, who is heads the DNA unit. No, not anymore.
Senior staff attorney.
He's a senior staff attorney
With the DNA unit.
with the DNA unit. You can feed me all my lines. That is a bit leading. For Legal Aid of New York City. And Clinton has a lot of experience with looking at how DNA truth can be found or not found with different types of software. And he has the perspective of a public defender as opposed to a public prosecutor. So, Clint, would you like to start? Thank you.
Morning, everybody. I'm going to try to get us back on schedule. But Deputy DA Zimmer actually did me a favor because I was worried I wouldn't be able to make a full hour of talk. So there was no collusion between the parties on that. All right. So, oh yeah, we got the. All right. So here we're in Congo. Dr. Perlin and I first met each other in 2015 when we were on a panel together in Arlington, Virginia, I believe it was, at a National Institute of Standards and Technologies conference, actually a symposium on lab error management. And we chatted a little bit. I was there presenting a paper that an expert and I had worked on, meaning he wrote it, and then I got to present it while he was on vacation, about a particular type of DNA software that we had been contesting in New York City called the Forensic Statistical tool, and I'll be talking quite a bit about that today. Then Mark and I actually worked together. Is everybody hearing me okay? Okay. Raise your hand if you don't, or otherwise. So. Mark and I actually worked together when he worked pro bono on an upstate New York homicide case that got national attention last year. The people of the state of New York versus Oral Nicholas Hillary, where Mark had actually, and Cybergenetics had been contacted about testing some evidence from the state crime lab by the prosecution a few years earlier. And after that led to no match or no statistical support for a match, and then a year later, no statistical support for a match, he was contacted by the defense in that case. And there was a potential of actually two competing DNA software programs, two probabilistic genotyping programs. It's a mouthful to say, being possibly admitted into court and competing and going head-to-head at trial in front of a jury. As it stands, the prosecution's DNA software was precluded by the judge, and there was no DNA evidence entered into the case, and it ended up with a verdict of not guilty. So. I guess my entree into DNA software was contesting that software called the FST that I mentioned before, and in late 2014, my team and I were able to get the FST software thrown out in two particular cases in trial court in Brooklyn, New York. At that point, I did not do the little dance that you see Jim Carrey doing here. One of my favorite lines from Liar Liar, I guess probably most of you have seen that movie. My favorite line is, "Stop breaking the law, a-hole." I thought about that when we were listening to Deputy DA Zimmer and the fact that she managed with her team to find the house that some guy had video recorded. And that kind of zealousness reminded me, don't break the law. And don't break the law in Kern County, for crying out loud. And the last thing, and I actually just disclosed this to Deputy DA Zimmer, I was a co-author of a amicus brief in the Billy Ray Johnson case to get the source code. So she and I are at opposite ends of the spectrum on the discoverability of that, or the accessibility of that, I should say. I shouldn't say discoverability, because she did mention that it could be discovered in some circumstances. But I think you'll hear from me, at least our perspective, that it is critical. It is effective assistance. It is not ineffective assistance to attempt to get the source code. And in that case, involving Trujillo, with my friend Mark Perlin, we were on opposite ends. But Dr. Perlin has, and cybergenetics have modified, I think, their position on this. And I think that's not only good for cases involving true allele, it's good for criminal justice. All right, so onward and upward. Goodbye, Mr. Carey. So I actually have a couple of slides on this I can kind of fly through. So right after we got that the DNA software evidence thrown out of court in late 2014, I had to help pick a jury and try a case where that DNA software tended to exculpate our client in another case. So hence the title Fickle Defender, and hence I guess the attention on that, because in the years to come, we had gotten it thrown out of one judge's courtroom, but there were other judges that were considering whether or not to include this FST software, and in those cases where we were challenging its admissibility, where we were doing a Fry challenge, the prosecution often brought up the case where I had been co-counsel and directed the city lab criminalist and brought out the evidence and brought out that it was validated by the state DNA subcommittee of the Commission on Forensic Sciences, and it was approved for use by the commission, and that they had done thousands of samples in order to do that. Whereas when we challenged it, we sought to address those issues in a diametrically opposite way. So it was almost as if, and I thought there was actually some disingenuity about I guess the charge that we were flip-flopping on this, because my initial reaction was, don't you know what I do for a living? But then we actually had a few judges sort of in their opinions allowing the software in, make note of it, that in other contexts, my law firm, the Legal Aid Society, and other public defenders were attempting to admit that evidence. So it was as if there was this collective gasp from the other side of the well. I think many judges get it. They get our role. They understand it. You'll see that the judge in the Collins case articulated it very nicely, but there is almost an emotional response. Well, the prosecutors cannot have this kind of serial monogamous approach to life, and they have to, in their administration of justice, can't sort of pick and choose apparently pick and choose the evidence against them. And that's, I think that may be at the source, but we're going to look and see what the underlying legal basis of our decision making is. So this is not a particular case example. This has to deal with the forensic statistical tool. I know you guys in the back may have trouble seeing the printout here, so I'm going to read it. This is just an excerpt from the validation paper, the published validation paper on the forensic statistical tool, or the FST, which was developed in-house at the New York City crime lab called the OCME, the New York City Office of Chief Medical Examiner. So this quote is from the authors who worked at that lab. The FST software provides quantitative weight to interpretations that would otherwise be qualitative, like cannot be excluded, included, inconclusive, no conclusions can be drawn, excluded. That one I particularly like. Or where no conclusions could previously be drawn. And that, I ask you to remember that last phrase. The FST software had been validated, had been approved for inconclusive samples where a criminalist is looking at a particular mixture and she or he cannot determine, rule in or rule out a particular suspect or defendant or any kind of comparison sample as part of that mixture. So I'm going to have to roll ahead a little bit. The FST software was validated and approved for use in late 2010, went online in 2011. And so part of our legal challenges, both in terms of admissibility and in terms of preparing for our defense at trial, was to get the underlying FST software source code. The lab vigorously opposed it. They said it was proprietary, even though they weren't really marketing it, even though it was a public agency. And from the get-go, in the initial admissibility hearings that we were granted, the cross-examination, the testimony is like, hey, dudes, you've already got everything you need. You got the validation studies, you subpoenaed that. We fought that a little bit, but then we agreed. You got the underlying formulas. You got the basis of the algorithms. You got these nice computer flow charts. You got what you need. You know what all the particular input parameters are, and that's all your experts are going to need to help you, and that's all you're going to need to cross-examine our experts at trial. So in 2016, a federal judge, because there was, I'm sure this occurs in Pennsylvania as well. You get state cases, and they're often gun cases with that touch DNA, and they are federalized, so they're prosecuted in U.S. District Court. A federal judge finally ordered the lab to turn over the FST source code, and for the first time in 2016 and 2017, a defense expert was able to review that source code and found a hidden modification that changed the values of certain mixtures and certain comparisons to those mixtures. And from that, we use that information to continue to fight to get the source code in state court as well. And so we got a series of affidavits. So we were able to develop a story. And the story is that after it went online, I believe it was in May of 2011, within a month, there was a minor modification made to the software. It's cosmetic, basically. But after that modification, it was discovered that certain likelihood ratios were coming up negative. And then the software was taken offline by the lab. Another modification was made, and that modification changed an appreciable fraction of the cases the likelihood ratio. The lab did not inform anybody about this. It did not inform the regulatory body, the DNA subcommittee. It did not inform the overall Commission on Forensic Science in New York State, which has a very sort of robust statutory scheme for review of lab protocol. It certainly didn't tell us in the defense community about it. No defendant knew about it. No defendant's lawyer knew about it. And this modification potentially biases itself towards higher likelihood ratios in certain situations. And it's akin to what Dr. Perlin has been chirping in my ear for years now, that it's throwing away data. It's taking entire locations and tossing it out like that, like the CPI of old. So to backtrack a little bit, when we were getting no love in state court for any of our motions to get the FST source code, we started thinking to ourselves, why don't we try to reverse engineer it? Because they're telling us we got everything we need. So what we ended up doing at the Legal Aid Society was to get engineering students from NYU to come in and work during the summer for free. And initially, we worked on spreadsheets because there were manual calculations in the validation study, so we could kind of see how they had things set up. And then from those spreadsheets, from those matrices, as the computer science majors would call them, one of our guys wrote a program that was able to replicate likelihood ratios on very, very complex mixtures and comparisons to those mixtures. And I'll just show you as an example. This is just one location, and it shows some of the inputs for the FST. If you were to print out that the Excel spreadsheets for this location, you need 845 sheets to show all the different kinds of combinations of what's called genotypes, or kinds of individuals that the FST would be considering. And that's just one location out of 15. So you're talking about hundreds and hundreds of thousands of calculations. We knew at that point we had sort of copied the Krabby Patty secret formula, at least for that mixture. But we were still getting some discordance on likelihood ratios, particularly likelihood ratios in actual casework. So we were a little bit stunted by it. That led in part to a complaint that we lodged with the Inspector General of the state of New York this past September, where we claimed, or when I say we, the Legal Aid Society, which is my employer, and then the Federal Defenders of New York, whose lawyers, Christopher Flood and Sylvie Levine, were the ones who had actually argued and gotten the U.S. District Court judge to order the source code to be turned over in a federal case. We teamed up and did what is called a Coverdell Complaint, because the lab, the OCME, had received a Coverdell grant, a federal grant for part of its work, and as that process allows for a complaint for certain types of misconduct. So we filed this back in early September, charging certain malfeasance, not just with the FST, but with certain other issues as well. Sort of a sins of the past kind of stuff, not necessarily the present practices at that lab, because they have sort of moved away from some of the more controversial practices, controversial techniques. However, they haven't sort of backtracked. They haven't allowed the access. They have not, in a sense, come clean about the issues with those techniques. And so that was part of our complaint that was lodged with the IG, asking the IG to perform an investigation. Well, the lab responded in September, and part of that was they were kind of directed to get some of my work, because I practice in Brooklyn. I'm consulting to roughly 150 lawyers in Brooklyn that are seeing tons and tons of DNA cases. I mean, there's been an explosion with touch DNA. I don't know what your practice is like here, but we get just case after case after case. Every gun that comes through gets swabbed. And so you're looking at 3 potential samples right there, and that doesn't include every other serious crime that's focused on where DNA evidence might be relevant. In any event, one of those cases, a gun case, involved a comparison to our client where the results by the criminalist doing a manual check was inconclusive, or no conclusions could be drawn. And because of that, they did not run the FST software. Well, because we had reverse engineered FST, we ran it, and we're getting a fairly significantly low likelihood ratio well below 1. Since we are usually within an order of magnitude, I'm thinking, man, let's get the lab to do it. We can call we can do what we did in that prior case. We can call the lab and criminalist and have them tell the jury that there's a mixture there, and the mixture is better described without our client, significantly better described without our client than with them in it. And it was validated to be used on no conclusions cases. It was approved. There's nothing legally preventing you from doing this. And the lab refused to do so. But they brought this up in this response. Hey, legal aid loves FST when it helps them. But, why are they complaining now that, that there's this hidden malfunction, which really doesn't make much of a difference anyway. And then they went on to cite some cases, and there are more cases that are in this than the lab cited in this response. They cited one in particular, People versus Bell, a Bronx case, where the judge went, in his decision, went fairly intensively into our use of, actually it was Excel spreadsheets at the time to try to recreate the likelihood ratio in that case, and in our use of FST at trial when it benefited the defense, as if this was some type of contradictory, thing. And so that brought up charges of sort of fair weather practice on our part. But we've been seeing this for years from the prosecution. I'm just going to read the highlighted part of this response to a Fry challenge that we did in a particular case. It is inexplicable for a party to argue that a type of evidence is so unreliable as to be inadmissible as a matter of law in one courtroom, while virtually simultaneously, which that's kind of true, presenting and arguing for the reliability of that same type of evidence presented in a neighboring courtroom. That doesn't matter that we're in a Fry jurisdiction, not a Daubert jurisdiction. And then the prosecution cited the New York Code of Professional Responsibility, provides guidance on this issue, Rule 3.3. A lawyer shall not knowingly offer evidence that the lawyer knows to be false. And then 3.3, and I believe that the Pennsylvania Rules of Professional Conduct, or Code of Professional Conduct, is codified, I want to say Chapter 204, 206, Section 81.4, something like that. But 3.3 is exactly the same as the New York language. It comes from the ABA model Code of Professional Conduct. And so it comes down to two things. You can't lie to the judge or the jury. And if you knowingly misrepresent something, you better fix it once you find that out. And then they attempted to rub our face in this. The people do not believe the defense attorney on those cases, guys like me who put the evidence in, don't believe the defense attorney on those cases violated the Code of Professional Conduct. Oh no. The people have a higher regard for the ethicality of the legal aid attorneys than that. Is there a word, ethicality? I don't know. But we reached the alternative conclusion. The defense attorney presented evidence they believed to be true, accurate, and reliable. So here we have the question presented again. If a lab uses a particular method to test evidence you introduce at trial, can you later challenge the admissibility of evidence produced with that method in a different case? And it doesn't matter if you're in a Daubert jurisdiction or a Fry jurisdiction or whatever kind of jurisdiction. Can you ethically do this? Well, let's take a look. I'm relying here on these are the New York Rules of Professional Conduct. I'm going to be talking only about 1.1. You've heard 3.3 already. And then we're going to move on to the ABA Standards for Criminal Justice, prosecution function and defense function. The fact that they've listed those functions separately is a good starting point as well. So in terms of the rules, Rule 1.1, right in the beginning, a lawyer should provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. That's just 1A of New York. We apparently like to talk a lot. That is it for you guys, right? There's no B or C. That says enough. Be competent. Know what you're doing. If it's going to be a challenging case, you better know what you're doing. And then the comment is expertise in a particular field of law may be required in some circumstances. So it's a should thing. I think should means that, that's kind of the basement. Don't go any lower. And then 11B in New York is, I guess we have more lawyers that need to be kept in line. A lawyer shall not, so opening yourself up to disciplinary action, shall not handle a legal matter that the lawyer knows or should know that the lawyer is not competent to handle without associating with a lawyer who is competent to handle it. So, get a co-pilot if you don't know that particular area of the law. In this case, if it were a criminal case, this is going to be a criminal case with DNA evidence, you better have someone who you can work with, who can work with your experts. And then 1.1c, in New York, a lawyer shall not intentionally fail to seek the objectives of the client through reasonably available means permitted by law and these rules, or prejudice or damage the client during the course of the representation, except as permitted or required by these rules. So if it's legal, if there's exculpatory evidence, you're kind of duty-bound to use it, no matter what you've said before. So then there's the duty to make qualified criminal defense. This is in the standards now. This is basically the sort of the Gideon principle. The government has the obligation to provide defense counsel, but in the standards, which we're all bound by, the ABA standards, it's qualified. It needs to. This is a defense standard. It's a qualified defense counsel. It's not just someone with a heartbeat and who's arguably awake. It has to be someone who's qualified. And it goes on to talk about making the lawyer's expertise available. Not expertise. Because after all, the lawyers are lawyers. They're not witnesses. They're not opinion witnesses. They're not expert witnesses. They are lawyers. And then there's also the defense standard, prompt and thorough actions to protect the client. Consider hiring, if you're unfamiliar with it, consider hiring an expert to deal with this. So there was discussion earlier about an admissibility challenge where there was not an expert. So the question is that ineffective or not? And then the defense standard duty to investigate and engage investigators. Again, consider hiring a forensic expert in your case, in your criminal case, and regularly reevaluate it. If they bring on Mark Perlin, or if they bring on Star Mix, or if they bring on some other probabilistic genotyping, evaluate whether you need an expert. Or evaluate whether or not you want to bring in Mark Perlin or Star Mix or some other probabilistic genotyping software. Okay, so zealous advocacy is mentioned in the prosecution standards and the defense standards. It's described a little bit differently. Just make sure I get. Pause for this important. Okay. So obviously both prosecutors and defense counsel are considered officers of the court, and they're designated as such in these two different standards. But the prosecutor is considered an administrator of justice. The defense counsel is three things, right? An officer of the court, client's counselor and advocate with courage and devotion, and someone who works for the administration of justice, not necessarily the administrator of justice. So it also talks about effective, high-quality legal representation with integrity for defense counsel. So in those kinds of approaches to zealous advocacy, we see a difference. Now, the relationship with expert witnesses is exactly the same, other than by designation, and that's the way it should be, right? I mean, you're dealing with a witness. You need to deal with that witness, and with fair dealing to everyone. And it's also brought out in both standards that the opposing counsel should each investigate the scientific acceptance of the particular theory or method that it seeks to introduce as well. So that seems completely appropriate and right. Now we get into really diverging duties here. You know, the standard, it's the same standard as in the prosecutor's relationship with the expert witness. The prosecutor should, if they get information from an expert that tends to negate the guilt of the accused or mitigate the offense, even if they don't intend to call Mark Perlin at trial because he's told them that there's no statistical support for a match, you got to turn it over. Doesn't matter if there's a report. The ABA standards say they should timely disclose that, and there's should means don't go below that. So that is a situation that is obviously it touches on Brady. Brady obviously, you know, the holding there involved a need for a request from defense counsel, but the standard itself doesn't talk about a request. It says, hey, you know about it, you got to turn it over. And then I guess there's the competing schools of thought on how to pronounce Giglio. That's how I pronounce it. I'm happy to engage in some sort of workshop later, so you can reform me. But in terms of impeachment material, Kyle versus Whitley, that I'm sure most folks here are familiar with, the duty, if you find something favorable, then you have to turn it over. And then there are specific cases involving forensics. Mitchell versus Gibson, the prosecution must disclose lab results that contradict the results they intend to introduce at trial. People versus Hillary, that Mark and I were involved in, there was a question as to whether or not that information had been disclosed. There was a representation by the prosecution on the record, I believe, that there was no report from cybergenetics, but there were emails, and those were eventually turned over, that alerted the defense that there was no statistical support for a match in the DNA in that case. And then there's also a more recent case, Buffy versus Ballard. There are, I'm just going to take note in terms of the prosecution's duties. There's one of the Annie Dukin cases, a federal case there where a sentence had been vacated because Annie Dukin was part of the prosecution team, and the prosecution disclosed her misconduct where she was dry labbing extensively. And then there's a very recent case, I think it was just reported out last month, Dominguez from San Diego, and it involved, I believe it was CPI, but the protocols had changed in between the first trial and the second trial, and there was communication between the lab analyst and the prosecutor about that should have been turned over. I was able to observe some of the United States versus Morgan case. There had been a talk between the prosecutor and an FBI scientist about some problems with low copy number testing that was used, and the Second Circuit ruled that was not necessarily discoverable, or Brady material, I should say. All right, so now we move from the prosecutor's function to the defense function, and we on zealous advocacy. I'm just going to play a little snip here because, and I think I may need this. All right. People getting CLE credit? All right.
Yeah.
I think you get an extra credit if you can identify this. Because this is a new standard, the tempered defense counsel's tempered duty of candor. In the 4th edition, it came in to the ABA standards, so just a couple of years ago. And this I believe, is the prelude in C major from the Well-Tempered Clavier by Bach. And I play it because I'm sure judges and prosecutors sort of hear this song when defense counsel come in the room. Shoulders start relaxing. Everything's much better. So, obviously, there's a duty of candor, but it's got to be tempered, well-tempered, by competing ethical and constitutional obligations. All right. I'm probably doing something psychologically damaging here. And defense counsel must act zealously within the bounds of the law and applicable rules to protect the client's confidences and the unique liberty interests that are at stake in criminal prosecution. And I think that speaks to not precisely on point to the issue of the of opposing counsel and some members of the bench taking issue with us taking different stands on it, but it definitely informs it. Now, the defense standard for the ABA in terms of presentation of evidence, it mirrors the Rule 3.3 from the model code of professional conduct. Again, you shouldn't lie. You shouldn't offer false evidence. You shouldn't put witnesses on the stand to lie, and that's pretty clear. And if you find out later, you kind of got to you got a duty to make things right, to let the court, the jury, and the prosecution know. But consider this: in cross-examination, and everyone, I don't think there's any dispute about this in sort of our criminal justice system. My belief or my knowledge that a witness is telling the truth doesn't preclude me from cross-examining that witness and doing my friggin' job, even though it may cast doubt on that testimony. And that is true for cross-examination, and it should be true for direct examination as well. Or I suggest to you that it's true for examination. And then this is from this is New York specific. This is just a jury instruction on expert testimony, and it goes over what the jury is going to consider, the qualifications, and it kind of mirrors a little bit the Kelly standard that Deputy DA Zimmer was talking about for the facts and circumstances upon which the witness opinion was based. So the sort of as applied use of the technique or the methodology. The accuracy or inaccuracy of any assumed or hypothetical fact. So if there's a hypothetical, they can consider that. The reasons given for the witness's testimony, whether a witness's opinion is consistent or inconsistent with other evidence in the case. You have a qualified expert. Expert is qualified to give an opinion. It says nothing about what the defense counsel believes or what the defense counsel argued in a prior case. And then there are arguments to be made that exculpatory and inculpatory evidence should be subject to different standards. Because the idea is that you would have I practice in Brooklyn. Mike Tyson's from Brooklyn. The perpetrator of the crime may look a whole lot like Mike Tyson, and the description may sound a whole lot like Mike Tyson, but where is that telltale facial tattoo that we all came to be familiar with and love? And what was it, Hangover 3 in Thailand? Without that tattoo, that is an exclusion, arguably, of Mike Tyson so that the standards possibly should be different. Again, I'm not a scientist, but it says that it should be something that should be considered. All right, so this is the case that we were involved with. The oral decision came down in 2014. The written decision came much later, roughly 6 months later, in 2015. Judge Mark Dwyer, who was sitting in Brooklyn at the time, he's now in Manhattan, had presided in the decision. He takes note of the fact that the prosecution, in its motion to re-argue, had brought up the fact that we were flip-flopping on use of the FST, and Judge Dwyer wrote that the court finds the argument of the flip-flopping of small moment. First, the advocate for a convicted defendant has little to lose by requesting DNA analysis, even under a procedure that is not generally accepted as reliable, if there is a chance that testing will produce exculpatory results. And he wanted to note, it would hardly surprise the court to learn, for example, that in one case an attorney would seek to admit exculpatory polygraph or bike mark evidence while opposing the admission of such evidence in a case in which it is inculpatory. That gives us pretty wide latitude, because what I've heard about polygraphs is as good as the flip of a coin. This court's view would require the exclusion of the types of DNA evidence contested here in any case in which either side objected to it. Because, you know, would be good for the goose, would be good for the gander. That would tie the prosecution's hands in the future. And this is back in the oral decision on the motion we argued earlier in 2015. I simply note that I don't consider it at all inappropriate for the defense to argue in different cases on behalf of different clients in different ways. And then there's, of course, the requirement for effective assistance of counsel. And this, I really should have updated this slide to say not just electronic data, but source code. We sort of we live in this sort of perverse island in New York State, and mostly in New York City, where we've had trouble getting electronic raw data because the local lab has been very, very good at arguing that it is not discoverable. And that I should have covered Dr. Perlin's ears at that point, because that you can't run Shule without electronic raw data. I mean, that's insane. But I think that is a painful phenomenon of the past, and the issues that will have to come up on appeal. But in order to be effective, in order to be good defense lawyers, not just good defense lawyers, but not ineffective defense lawyers, and who wants to be ineffective, there needs to be real challenges to software, any software, and a consideration of what the underlying recipe that is cooking this particular dish that is being served to the jury. And so an example here is that there are software out there that are getting radically different results. This is a study from 2015 that was published in FSI Genetics from an Italian lab that uses 3 different types of software. There's 2, I'm not going to get into exactly what they are, but there's 2 that are non-continuous, so they don't look at all the data. There's another one that's called, it's a DNA View, developed by Charles Brenner, California, that it looks at peak heights and therefore is considered continuous. Radically different results. And this is a real case, real suspect, comparison of the suspect to evidence samples. In one sample, the 2 semi-continuous programs were slightly exclusionary, slightly below 1. DNA View, the other one, had a likelihood ratio of 10 to the 8th power. And Dr. Perlin has a degree in mathematics, a doctorate in mathematics. What is the 10 to the 8? Is that a 10 million? 100 million. I was only 1 order of magnitude off. That's good for me. That's concordant? Well, it's not concordant when it is 10 orders of magnitude off. Well, thank you very much. But 10 orders of magnitude off from the other two software. And these other two software get admitted in court. One's been admitted in court in the United States. And then in another comparison of a particular mixture, there was a 12 order of magnitude difference, which I think is a trillion. And then in another, the two programs that were more like each other had similar results that were slightly inculpatory. The mixture tended to be more likely or more probable if the suspect was in the mixture. The continuous program was 10 to the negative 14, so extremely exclusionary. And in comparisons with manual calculations are, John Donahue can explain it much better this afternoon, are visual comparisons of the evidence from the crime scene with the suspect's profile. In one study by the developers of StarMix, which really should be called Stormamix because it's taking the United States by storm. It's adopted by the FBI and many state labs. There were comparisons with the manual calculations, the visual calculations of trained professional criminalists with the software itself. And you really can't see the different colors here, but there are a significant number of differences. There are times when StarMix would include a suspect, when the criminalists would exclude him or find the suspect inconclusive. There were times when the StarMix would include while the criminalists were exculpating or finding the suspect the comparison inconclusive. Generally, it was reported that generally StarMix provided higher likelihood ratios, and so in that sense were less conservative, less favorable to the defense if that were played out time and again in court. I'm just going to. I promise to get us back on track. Now I'm 6 minutes over, but I'll note a couple of resources. Dr. Erin Murphy, she's done a bunch of different stuff around DNA forensics, including familial searching. She wrote back in 2008 a law review article on inferences and arguments in second-generation forensic evidence, and then more recently had published Inside the Cell, The Dark Side of Forensic DNA. I just want to touch quickly on the example that I've mentioned several times before, People versus Hillary, that Dr. Perlin and I both worked pro bono on, and I worked along with 4 other lawyers from New York City, from the Legal Aid Society, and at the time the Bronx Defenders in New York City, because we wanted, several things attracted us to this case, one of which was the fact that we knew StarMix was going to be rolling into New York City and wanted to be more familiar with it. And the other was that we found the facts of the case very compelling. You may hear more about the comparison here. I mentioned before, no statistical support for a match, leaning towards exculpatory for the one sample where, and in that situation, it seemed that true allele was concordant with the finding of the criminalists in that case, the scientists working at the state lab. StarMix, however, as it developed and brought in new features, had a sort of a moving target of rather inculpatory likelihood ratios, inculpatory statistics, but those statistics did not get admitted into court. I'm going to have one final thought here. There's Mark and I met in 2015 at a symposium hosted by the National Institute of Standards and Technologies. NIST, are called NIST. NIST has announced a study where they're going to be sending out samples to different labs, public labs, and maybe private labs as well, where they say, hey, run your probabilistic genotyping software. Let's see what we got. And they've already done some fairly extensive studies on mixture interpretation. So I think this is going to be the first widespread analysis of it. John Butler is sort of the fellow forever at NIST. He is arguably the most famous DNA forensic scientist in the world, author of the textbook on forensic DNA testing. And he was recently interviewed by ProPublica, and here's a quote: "Just because you have a big number doesn't mean that you got the right person." That is from somebody of some weight in this field. So, in terms of rendering effective assistance of counsel, I suggest to you it's just tantamount to getting the source code, requesting the source code, getting that expert at admissibility hearing, if it's granted, in order to render zealous advocacy. All right, thanks so much.